Okay, and I'll start it, and then Jamie, I'd give it just a couple seconds while people join.
Sounds good. Well, good afternoon, everybody. I think we'll get started here. Welcome. I'm Jamie Cashman with ISAC, and I want to thank the members of the State Court Administration who are joining us today for this webinar. With us, we have Amber Shanahan Fricke, who's the Senior Staff Attorney. We also have Kent Farber for the Director of Finance for the State Court Administration. And lastly, we have Bob Gass, who is the State Court Administrator. So what they will be providing to us today is an overview of the court debt programming review, explain the current issues affecting counties, and demonstrate how those issues affect individual counties by walking through a searchable spreadsheet that details how counties were impacted by incorrect programming issues in fiscal year 21 through fiscal year 24. This spreadsheet will be made available to all counties after the meeting. And so for some housekeeping, we'll be taking questions throughout this webinar. And please go down and utilize on the Zoom options of the chat or the Q&A, and we'll answer questions as they come along. And so with that, I'll turn it over to you, Amber.
Right. Good afternoon, everyone. All right. I'm going to turn it over to our State Court Administrator, Bob Gass, to kind of get us started a little bit.
Okay, and thank you, Jamie, for the introduction. And hello, everybody. Thank you for joining us today. We're very happy you're here. We very much want to involve all of you, the stakeholders, as we work through this issue and especially on those fiscal years 21 through 24, to give you an overview of where the programming was wrong, and show you what it looks like, and then to make you aware of what is happening now and what our plans are for the future. And so just to give you an update on where we are right now are the programming changes that needed to be implemented based on our legal review and our outside review of programming changes were implemented in late November. And for the fiscal year that we are currently in, fiscal year 25, those distributions were now correct. And so our programming is correct moving forward. For this fiscal year, we are able to make those corrections and have done so. It's the problematic years are really those years FY21 through fiscal year 24 that we're going to talk about in depth and show you the numbers. And so that's what we really want to zero in on today, because we do not have the authority to redistribute those years, but we want to make you aware so we can continue to have conversations. Amber, if you can go on to that next slide. So just to give you a little background and a timeline on where we're at, in late 2021, early 2022 is when me and my team came on in the State Court Administrator's office. And there were some questions that were starting to be raised about what our court debt programming was looking like. And we received a couple of external inquiries. And so we looked at it. And initially, because the court debt programming was changed really in the middle of COVID, the initial view before we really started digging in was, well, the tickets were down, arrests were down, so there would be a little bit of a drop off in the revenue that was supposed to be generated, that was estimated to be generated as we move forward. But we also realize at the same time, that's not the full extent, that's not the full question. And so we met, we had a feeling there was something else going on. We talked to a couple groups, and we decided then we're going to bring in some independent eyes, because as we began to look at it, we noticed a complexity that was in the law, and then a complexity within our system. And every time we'd find one thing, it'd lead to 5 more. And so we thought we need some independent eyes on this to take a look. So we hired a contractor, and that's from the National Center of State Courts, to come in and really do a thorough look at our programming based on the parameters that we identified. And so they came in, and it took them a full year due to the complexity of the system to go through that programming and give us scenarios. What they were not able to do for us was an independent legal review. That was not something they were able to do. So after we took their report and our parameters, then Amber led the team, and mostly herself, to go through and independently review every legal option there was in the parameters. And she's issued one report and one memo, 65-page report, and then also a 45-page memo that details legally what the changes are now, should be, and what they were previously, and how that analysis was done. And so then in January of this year, programming changes started, and then the other memo came out in October, as I've said, and then in late November of this year, the programming was fully implemented, and it redistributed everything retroactive to July 1st of 2024, or the beginning of fiscal year 25.
Okay, I'm going to turn it over to our Director of Finance, Kent Farber, to tell you a little bit about court debt distribution and just kind of the background of that.
Thanks, Amber. Good afternoon, everybody. So it's important, before we get into the spreadsheet and start showing some of the numbers, I think it's important to kind of go through the background and explain how court debt is paid, how it is calculated, and how it's distributed by the judicial branch. So all court debt distributions occur through the JBIT case management system. And so when you hear the term JBIT, that's Judicial Branch IT. And so through the case management system, which is really the management system for all of our clerk of court offices, that is where all payments are being processed. And that is the system that calculates what the distribution should be. Both county attorneys and the Department of Revenue can collect delinquent court debt. They organize, they can contact, communicate, but ultimately all of those payments do get made through the clerk of court office. The exception would be income tax collections through the state's set-off program or the state's vendor offset program, where that money does come in centrally to our IT department, and then it is processed through the case management system. The clerks of court, so they receive all of those voluntary payments, and then things like set-off or the involuntary court payments, they're still processed through the case management system. And the clerks are responsible for paying the local entities using their data from the JBIT case management system. So those checks from the local clerk of court office go to all of the local entities that are receiving distributions from the court debt. And so they do not go through the state accounting system, and they do not go through state court administration's finance area. It's also important to understand that when you were talking about court debt, there's actually 4 different collection types. So when we start talking about the programming, and then you go through how this has to be set up, there's 4 different ways that it can actually be collected. And so the first is the easiest. It's the case isn't in collection. So the person has paid, they're fine. If it's a speeding ticket, you mailed it in and paid it. If you went to court and you had a fine, you went into the clerk's office before it was delinquent, before the 30 days were up, and you paid it. After that point, then there's some different routes that those collections can take. And the first is through the Department of Revenue, through their collection programs, whether it's a collection portion or it's the set off, the automatic set off. But then there's also the county attorney collections, and the county attorney collections is a little bit more complicated because there's two different paths that it can take through the case management system and that distribution. And that's whether the county attorney in that county has met their threshold for the fiscal year or they have not met that threshold. And so Amber's going to talk a little bit more about what each one of those means.
So as Kent touched upon, we have different programming for each of these collection methods. And for a case not at collections, the court debt recipient receives 100% of the payment. But for cases at collections with the Department of Revenue, the payment is split 15% to the Department of Revenue as a collection fee and 85% to the court debt recipient or recipients. Whereas with county attorney collections, before threshold, 28% goes to the county for a collection fee and 72% goes to the court debt recipient. After threshold, 28% goes to the county as a collection fee, 5% goes to the county attorney's office as a collection fee bonus, and 67% goes to the court debt recipient. There are types of court debt that the collector is required to collect but does not receive a collection fee for. We'll touch upon those later.
So just to provide some context to what's being processed in the case management system on a yearly basis, all the 100 clerk of court offices across the state, and that's because we have 2 clerk of court offices in Lee County, so we have 100 clerk of court offices, process roughly 500,000 or more criminal cases each year that are processed and disposed of. And there's over $240 million in court debt assessed per year. Obviously, that number varies, but it helps give you an idea of the amount of volume that's going through this system. And so in the 4 previous years, we talked about the amount of court debt that was assessed, but the amount that's collected is different. Obviously, it's less than what is actually assessed. And so during the time period that Bob was talking about that we had focused on, fiscal year 21 through fiscal year 24, there was just over $587 million in court debt that was collected through the clerk of court offices. And so it's important to understand this money is not used to fund the judicial branch per se. This is money that has specific code required distributions, whether it's to the state general fund, it's to other state funds, or it's to local entities. And so the one caveat to that is that we do have a technology fund that the legislature has chosen to fund by taking the first $7 million in court debt. And it's not the first, because there's 3 different types of funding that this takes place. Before any court debt is distributed each fiscal year, there are certain buckets that we have to fill up. And one of those is that $7 million court technology fund, which is used to fund technology in our courtrooms. So that's the only place where any of this money is actually going to the judicial branch. The rest of it is being distributed to other state or local funds. And so during our analysis and the work that legal and Amber has performed, JBIT and our IT has performed, and finance has taken that information and put together a calculation on the total amount that was over allocated to the state general fund and under allocated to the other state funds and the non-state funds. And so when you look at these numbers, negative or positive, think of it as what would be the necessary adjustment if you were going to correct it. And that's why that's a negative number on the state general fund, because we calculated that it was over allocated $27.5 million during those 4 fiscal years. The other state funds were under allocated $23.6 million. And then non-state funds, which would be the local entities, were under allocated $3.9 million. And so when you go back to the amount that was collected during those 4 years, $587 million, you can see that that $27.5 million was just under 4.7% of the total that was collected. And the actual non-state funds account for about 0.6% of the money was collected during that time. All of the money was collected, it was just distributed to correct locations. And that The other thing that Amber has put on the slide, and it's very helpful to understand, when we were talking about county attorney collections, and after a county attorney and that county attorney county has made their threshold, there's an additional 5% that gets sent to the county attorney for meeting that threshold for every court debt from that point forward and through the rest of the fiscal year. None of these numbers include that threshold, and that's due to the time constraints and the amount of time it would take us to go back and calculate for the 99 counties when each one of those counties, county attorney collecting counties, met that threshold, and making those adjustments. So none of those 5% payments to the county attorney after a threshold has been made is included in any of our estimates.
To be clear, county attorneys are hitting that threshold at some point in the year. They aren't hitting that, they don't get that 5% on all of the court debt collected that year. But at some point in the year, every county is hitting their threshold. And so if there's a discussion about redistributing funds from prior fiscal years, I will say that county attorneys were entitled to something for those years. We don't have the exact number. It's not 5% on all of the court debt, but there probably would need to be some sort of a stand-in to account for the monies that were not paid to the county attorney as that after threshold amount. So I just want to be clear on that we do think that the 5% is part of the picture on part of the money, but it was simply due to practical constraints that we could not accurately and timely provide that number to you.
Thanks, Amber. And so just a little bit of a diagram here that kind of shows the process on how finance gets involved with this. So as we talked about, all of these transactions and this information is housed within the JBED case management system. And so we actually have accountants on staff whose job is each month to go in based on the information from the case management system and sweep in the money to the state treasury and go ahead and make those deposits into the state accounting system. That's the point where it enters the state accounting system. Any state payments, whether it's the state general fund or those other state funds, is processed in a month-end sweep out of the case management system and out of the clerk of court office's accounts into the treasurer of state, and then it's deposited into the correct accounting string. All of those local payments are being made from the clerk of court through the case management system. And so it's not entered into the state accounting system.
Today, we're going to go over 4 different issues affecting counties. The first issue is the county attorney collections programming framework. There's 2 aspects of this. One is a county attorney collection fee not being provided on some court debt that was owed by county and city entities. The other is a county 9% on criminal fines not being provided when the case is in collections with county attorneys. The next is a new strict legal interpretation of court debt that is subject to a collection fee unless it's exempt pursuant to 602.81073 or 4. Commercial vehicle violation citations pursuant to the road use tax fund, which has resulted in an overpayment to counties between FY21 to FY24, and then an underpayment previously to the juvenile detention home fund. So we're going to go over those 4 issues. So the issue with the county attorney collections programming framework. That programming framework was built about 30 years ago, and some adjustments were made here and there. But overall, the framework had not been fundamentally changed until very recently. And we started receiving questions. This is the first question as we were implementing Senate Bill 367, which had to do with Department of Revenue collections programming. And it was after we were receiving those questions that we realized, as we dug in further, that we needed to fundamentally change how our county attorney collections programming framework worked, because it was wrong. And we have since then rebuilt the framework for our county attorney collections programming to work correctly. What it was doing wrong was two major things. If the court debt was set to distribute 100% to state recipients, or for criminal fines pursuant to 602.81064B, which is most criminal fines, or on a proof of financial responsibility ticket, the way the ticket distributed, the county attorney received a collection fee, the county and the county attorney, and then the rest of the distribution went entirely to the state general fund. Well, if this was due, if it fell into the first category of being due 100% to state recipients, like if it was a filing fee, that was a labeling error, which is not good, but it's not a misdistribution. But for those criminal fines or proof of financial responsibility tickets, it resulted in a misdistribution. And as it affects counties, particularly in county attorney collecting counties, it meant that the counties did not receive the 9% due on the criminal fine, because most criminal fines fall into this category of fines that are due 91% to the state court administrator, who puts all but a small portion into the state general fund, and 9% to the county. And that 9% to the county was not being provided. The second way the county attorney collections programming framework was not working was that if it was not in one of those categories, which typically meant it was not due to the state, and it was not a criminal fine, and it was not a proof of financial responsibility ticket, then the county attorney or the county as a collection fee did not get their collection fee. And the remaining amount would distribute as though the case were not in collections. And this plays out differently depending on who the court debt payment was going to. So sometimes the court debt payment would be going to the sheriff, a county entity. Other times the court debt payment would be going to a city. But now that has changed. So now counties are getting a collection fee on court debt, unless that court debt is explicitly exempt from having a collection fee deducted. So here is an example of how a $100 payment would be distributed for a criminal fine. And you'll see here that in black is how it should distribute. So it should go $28 to the county, $6.48 to the county general fund, $65.52 to the state court administrator, who would provide 85 cents to the emergency medical services fund, and $64.67 to the state general fund. But that's not how it was distributing. It wasn't distributing anything to the county general fund, and it wasn't distributing anything to the emergency medical services fund. So we changed this, and now it's distributing correctly, but before it was not providing that amount to the county general fund. The other way the county attorney programming was not working correctly is it wasn't providing a collection fee on essentially entities that were not 100% the state. So this played out with sheriff transport fees. These, we call them collectively sheriff transport fees. These are the fees under section 331.655. These are typically smaller fees that almost all of them have to do with interactions with the court, serving a subpoena, that type of thing. And these are commonly set up in a court case and treated as court costs. And we've never provided a collection fee to the county attorney for those, but we have been providing a collection fee to IDR for it. Additionally, the same thing with city fines, fines where the city's a plaintiff, or city ordinances. We've never provided a collection fee for county attorneys. But in section 602.81074, just like 602.81073, it does not say that that type of court debt is exempt from a collection fee. So my conclusion was, if it's not on that list as exempt from a collection fee needs to be provided. And so we are now providing a collection fee there. So while before, when someone made a payment toward a sheriff fee pursuant to 331.655, that entire amount would go to the sheriff's office. But now, if it's in collections with the county attorney, before thresholds met, that payment is only going to go 72% to the sheriff. 28% of it's going to go to the county for the county attorney's collection fee. And if it's after threshold, then the sheriff is only going to get 67% of it, with 5% going to the county attorney and 28% to the county. So it's still, when it has to do with adding a collection fee to a county entity, it's kind of shifting the money around within your county a bit. But from our perspective, we need to match it to the law. I don't know how that plays out internally for you all. But the bottom line is, these types of court debt are not listed as exempt from a collection fee. And so we're going to provide a collection fee. And we've already been providing a collection fee when they're in collections with the Department of Revenue. And this is really making that equitable. In addition to the issues that we specifically analyzed in the 65-page report and the 45-page memo, we've also made changes to a few other types of court debt that we are already providing a collection fee to IDR on. It's not on the list that was ineligible for a collection fee, while the payments paid to are collected by the clerk of court in the cases in collections with a county attorney.
Hey,
I touched upon
Amber?
early. Yeah, go ahead, Jamie.
I think we have a question here, and we'll try to take them as they go.
Yeah.
So does the resident see that a collection fee is charged on their bill? It's just not being distributed, or do we need to make changes to the current forms and process?
Will you say that again for me, please?
Okay, so the question is, so does the resident see that a collection fee is charged on their bill, it's just not being distributed, or do we need to make changes to current forms and the process?
So by resident, do you mean an obligor, or do they mean an obligor, a person who owes the court debt?
I do believe, if Heather, if you can clarify, yes.
Okay, so it does not affect the obligor, because the obligor owes the same amount. It does not increase their bill whether a collection fee is provided or not. It affects the obligee. So the court debt recipient has to share their payment with the collector. It does not affect the defendant or the obligor. It's really not, it shouldn't make any difference for the defendant, because they should get credit for the payment even if it's toward the collection fee.
All right, thank you.
I touched upon before that there's a list of court debt that's exempt from a collection fee in 602.81073 that has the list of court debt exempt for the Department of Revenue, and a very similar list in 602.81074 for county attorney collectors. And there was a big change to 602.81074 in Senate File 457, and which struck from that list of exempt court debt the criminal penalty surcharge, the DARE surcharge, the law enforcement initiative surcharge, the county enforcement surcharge, and sheriff room and board fees. Prior to Senate File 457, all of those types of court debt did not have a county attorney collection fee on them. But Senate File 457 struck those from the list. While those surcharges were repealed in Senate File 457, and those room and board fees were moved to the civil realm for collection, going forward, we're not charging those surcharges anymore, and we're not bringing those room and board fees through the criminal cases anymore. We still continue to collect on those old surcharges and collect on those old room and board fees. And my conclusion is, because they're stricken from the list under 602.81074, and because they were never added in the list when it was created in 602.81073, is that a collection fee will now be provided to the collectors for those old surcharges that have been repealed and the sheriff room and board fees. So what that means is sheriff room and board fees now do not go 100% to the sheriff, but rather are subject to a collection fee that goes 28% to the county before threshold, and after threshold, 28% to the county, 5% to the county attorney, and then 67% to sheriff room and board. So thus far, we've primarily talked about issues where counties, particularly county attorney collecting counties, are going to see an increase in money because it was an underpayment between FY21 and FY24. The next issue is where counties were overpaid due to a programming error. This is commercial vehicle enforcement citations. Section 602.81088 was not amended with Senate File 457. But our programming for that code section broke with Senate File 457. Basically, what it does is it says if a commercial motor vehicle officer writes a ticket on a commercial motor vehicle, all that money should go to the road use tax fund. It shouldn't be distributed like a regular criminal fine. That's not what our programming was doing. It was distributing it just like a new regular criminal fine, going 91% to the state court administrator, who distributes most of that to the state general fund, and 9% to the county. Well, that was wrong. It should have been still 100% to the road use tax fund. So between FY21 and FY24, counties were getting 9% of these tickets that they should not have been. And because these tickets are written against commercial vehicle licensees, these tickets get paid. There's a high rate of pay. And so this has been a lot of money that counties were overpaid. So you'll see a dip because this programming has been fixed. But as we mentioned earlier, we don't have the authority to redistribute the funds from prior years. So that is not something we're able to adjust. Okay, the next issue we have impacts the Juvenile Detention Home Fund. So there was an error with the criminal penalty surcharge. That was the surcharge that was added to criminal cases, criminal convictions prior to Senate File 457. It was a 35% surcharge. And there were some questions about how it should be utilized after Senate File 457. And you'll see that from fiscal year 21, it was about $2.2 million that were under allocated to the Juvenile Detention Home Fund. Another nearly $9 million that was under allocated in FY22. But then we made a programming change in December 2022, which remedied the lack of distribution to the Juvenile Detention Home Fund. But when we made that change to make the distribution correct on the criminal penalty surcharge, we caused an error that removed the collection fee on the criminal penalty surcharge. And this was our big example of why we stopped trying to make changes along the way and why we waited until we were completely done with our legal review to do all of the programming changes at one time, because when we made one change here for the better, we broke another part. So what you'll see here is, due to a programming error early on, there was a big under allocation to the juvenile detention home fund, but most recently it has been mostly right, except the collection fee was not provided. And so there will actually be it's the amount being distributed to the juvenile detention home fund will decrease by the amount of the collection fee, because we've already remedied the lack of distribution to the juvenile detention home fund, but now we need to provide a collection fee to it. But the collection fee will go either to the Department of Revenue or to the county as a collection fee. Okay, does anyone have any questions on what I've just shared?
Not seeing any questions at this time, Amber.
Okay,
Please.
Kent, I'll turn it over to you then to share the financial impact spreadsheet.
Very good.
Absolutely. Thanks, Amber. Looks like you might need to unshare so I can get into it. Sorry.
There we go.
All right. Hopefully you guys are going to be seeing one of my screens here with an Excel spreadsheet on it. So as Amber was talking about it, Jamie mentioned at the beginning, what we want to provide and what we've tried to provide to all of the stakeholders is information about what is the impact going to be on your entity for these programming changes. And so we're trying to put the data together. We're putting as much information as we can out there, and we want to be able to explain to you what each one of these different pieces of information is. Now, as we've talked about, this is the operating system. It's the case management system for the clerk of court offices and really the judicial branch operations. And so it's not in the state accounting system. I can't go in and run a query based on a fund or an account and pull out detail, balances, anything like that. We strictly rely on our JBIT staff and their programmers and their operators in there to be able to pull information out for us. And so one of the challenges that we've run into is that these are the same people that have been working on the programming changes. They've been doing the testing. They're the ones that are having to change all of the reports. And as we talked about at the beginning, when Bob provided updates in late November, all of the programming changes and the adjustments for fiscal year 25 were put in place. And so we're going through our month-end process right now to be able to, after those changes have been made. And so they're finding a lot of bugs that are needing to be fixed and cleaned up. And so when you have the same people that are doing all of that, sometimes it's a challenge for us to be able to get the information that we need. So we have the spreadsheet. I'm going to show you the basics of how it's going to be laid out. It's not ready to be released yet because there's still information we're waiting for to be able to put this out to everybody. But what it will do is help answer questions about, okay, if the programming would have been correct, how would that have changed my payments in fiscal year 21? How would it have changed it in 22, 23, and 24? And so you'll have an understanding of what are these changes going to mean to the revenue that's coming in. And Amber's raised a very good point too, is that understanding that if you go in and look and you pull up your county and it says, okay, over those 4 years, I should have gotten an additional $500,000. A lot of that is just money that's coming from other local entity payees that are now paying into that county attorney collection piece. And so it's not all just new money. It didn't go to the state general fund, all of it. If you remember back to the beginning of our presentation where we talked about we over allocated $27.5 million over allocated to the state general fund, but at the local level it was only less than $4 million that was under allocated. And so when you see those numbers, these numbers are going to be greater for the counties than that $4 million, but it's because it's how you paid for that was coming from the other local entities. So I'm going to show the spreadsheet. We're not going to be able to release it today. We're going to be able to release it hopefully soon once we get some the ability to use some of our IT programmers to give us the information, the final information that we need. But the way that it's set up is that it's going to be searchable. So each county will be able to pull up the spreadsheet, and this top left-hand corner, they can type in the name of their county, and it's going to populate essentially 5 different rows. And so it's going to show a summary for fiscal year 21, 22, 23, 24, and then a combined where it's going to show you the total over those 4 years. And so when you go from left to right, what it's going to be putting together is showing that based on all of the different programming changes, and this is where we're going to work to improve on some of the communication, but it's talking about the FIN codes that are in the case management system, and then really a brief description of what that is. And we want to have a cross-reference so that we can point back to Amber's analysis that tells you, what are we talking about with this adjustment? What did that adjustment do? How was it set up before? How should it have been? And so we can provide that. So it'll show what the impact was to the county payment in total for that fiscal year based on that adjustment. And so in this case, Adams County should have received $528 less based on this adjustment. And it'll provide this information across all of the different adjustments that should have impacted the county as a payee for court distribution. And so that's the idea behind it. We're going to be able to provide hopefully more understandable information about what each one of these columns are and what is really happening there. But we want to be able to show what the impact was to each county and what that cumulative effect was over those 4 years. And so I just did, as an example, type in Madison County. Type in Madison, you hit enter. It's going to populate the information that's in the data table for Madison County for the 4 years. And so this isn't final. So don't pay any attention to these totals right now because we're still waiting for some information from our IT department. But this is what it's going to be able to do for us, is it's going to be able to show, okay, what are dollar amounts for each of the counties. And then at that point, if you have any specific questions, then we ask that you reach out to us and we'll be able to provide whatever information and answer whatever questions that you have. And with that, Amber, do you have any further comments, or Bob, do you have any further comments?
I want to touch on something that I kind of breezed past a little too quickly earlier. We talked about the county 9%, where if a case was in collections with the county attorney and it was a criminal fine, our distribution was not providing the 9% to the county. The Sheriffs and Deputies Association had been in contact with us about that 9%, and they were having some trouble finding on their communication that they received from clerks where that 9% was, the 9% of the criminal fines, and having difficulty having that information to talk with their counties with about. And so we're working on getting more and more clear information in our check stubs, and I think we are improving it, but I don't think we're all the way done with that. But the key FIN codes to look at for that are MH44 is the main one, and then also CM78. And the reason why sheriffs are asking about that is because under 356.7, you may be familiar, basically says, and you can look at it, please look at it yourself, but basically says that the county needs to provide about 60% of that for purposes that are basically related to the sheriff's budget. So that's why they're really looking at that 9%. And we're wondering, hey, why isn't this money coming in? And that's why they started raising the questions that helped us really dig into this issue. I think I see a question.
Yes, so this is good info, but what is the next step to make all the entities whole under statute?
It's a great segue to let Bob speak.
Yeah. Thank you. Great question. And so that goes into what are we going to do? What's our next steps? So first and foremost, we're going to get you the remainder of this data, as Kent has said on this spreadsheet. As we said before, because it's in past year's distributions, we do not have the authority to redistribute. So we want to reach out to all the stakeholders, let you know what is being done, let you know that the figures that we are talking about. And then we need to work with the legislature and the stakeholders to figure out how to make those distributions. Right now, we do not have that authority from the legislature to make those distributions, but we're going to continue to talk to all of the stakeholders. And as you have questions, as Kent said, please ask. We're going to make sure we get you all the information you need. And we're also going to present the same information to the legislature so we can talk about how to make these past year's distributions. And I just want to remind everybody again, the big key is this year's distributions we are able to correct, and they have been corrected. But those past years, it needs to go to the legislature for a final resolution on how that is distributed and how we get that to all of the stakeholders. And so that's where we're at on that. We can assume a lot of things or think things are going to happen. We would assume meetings will be held with all stakeholders to discuss how that happens. That's what we intend, and to keep you as stakeholders informed of all the amounts and everything that's being done. Now, other things we're doing to give you all some confidence that we're not just pulling rabbits out of a hat. So we have made we have our legal analysis done. Programming has been changed. But since we did this programming internally, we wanted to make sure that we weren't the only ones looking at this programming change. And so we have hired an independent company to go through the programming and ensure that the legal analysis that was done is programmed correctly. And it's a set of independent eyes. So it's not our internal people doing this. We've got an external company that is just getting kicked off phase one. Phase one is completed, actually, getting ready to kick off phase two of the programming review. And that is being done. So we're paying an independent company there. The second thing we're doing is we are working with the auditor of state to go through and look at the numbers that we have presented, and ensure that those numbers are indeed accurate. And again, based off programming. And so if everything is programmed, the programming is working effectively, are those numbers correct? And like I said, we're working with the auditor of state to verify those numbers too, because we want to be transparent with all the stakeholders, and we want to make sure that that money that you're seeing on those spreadsheets is indeed correct. We are pretty confident, but we want to ensure it, and we want to make sure that our eyes are not the ones that are just the only eyes that are doing that. And then last but not least, the other thing we're undergoing is an internal review of our case management system as it works with the financial piece of this, which is the part that was programmed incorrectly. And so we are going to hire an independent firm to come in and essentially do an audit of our entire IT system as it pertains to finance, down to the staff level, to ensure, do we even have enough people that are programming? Kind of relates to what Kent said on the information. Do we have enough people in the right place to run this financial system in conjunction with our case management system? So those are the three big things we're doing. But per the question, I want to say we are going to work with you as the stakeholders and the legislature to get these past year's distributions figured out.
Do we have any more questions? Please utilize the chat option down below. All right, seeing none, certainly want to thank you, Amber, Kent, and Bob for presenting today. Certainly from the ISAC perspective, in terms of moving forward, we certainly want to work with you to figure out what the true impact is. And so once we get the final spreadsheet and so forth, we'll get that out to all ISAC members, and then also a copy of this webinar. And then moving forward and then talking about those next steps, Bob, we certainly want to work with you. And if we have to have another webinar to outline what those next steps are, we'll certainly provide that for all ISAC members as well, as we did today. So again, I want to thank everyone that joined us today. And I will certainly also, once we get the spreadsheet out, we'll provide options then if there's further questions, whether it be another webinar or we'll send them to the state court administration for follow-up and so forth. So again, I want to thank you all, and I hope you have a wonderful day. Thank you.
Thanks.
Thank you, Jamie.
Thank you.